A federal high court in Abuja has directed two aggrieved directors of Green Energy International Limited and its chairman, Professor Anthony Adegbulugbe, to explore out-of-court settlement in the matter brought before it. Justice Bolaji Olajuwon gave the directive shortly after the resumed hearing in the matter. The directive came as the directors demanded that the shares alleged to have been illegally allotted to Adegbulugbe, Olusegun Ilori, Glory Bright Investment Limited, and Grand Energy Limited be offered to the original shareholders. The directors, Dr. Bunu Alaibe and Mr. Ayodele Olojede, have locked horns in a legal battle with Adegbulugbe over ownership of the oil and gas company. NAN reports that while Alaibe and Olojede are the petitioners in the suit marked FHC ABJ CS 1390-2020, Green Energy International Limited is the respondent. When the matter was called, counsel to the respondent, Bembela Anichebe San, informed the court that he filed a motion by notice of withdrawal on March 3rd. Olajuwon then asked Anichebe what the development was after her advice on the last adjourned date that the parties should work towards reconciliation. She said Vincent Oho, who held brief for Etigwe Uwa San, counsel to the two directors at the last sitting, told the court that the first peace move broke down because what was offered to Alaibe and Olojede were unacceptable. The judge recalled telling Oho to tell his clients to open up on the terms of settlement they wanted. The senior lawyer said that he spoke with Uwa, counsel to the directors, on telephone with a view to meeting and reviewing the earlier meeting held. NAN reports that Justice Ijoma Ojukwu, who was the presiding judge before her transfer to the Calabar division of the court, had given the parties the leave to explore a reconciliation option. Anichebe told the court that he and Uwa could not meet physically and only spoke on phone on the matter. Responding, Uwa confirmed that the two counsel spoke on telephone after the last sitting. Uwa, however, restated the commitment of his clients to settle the issue. He said given that oil assets were involved in the matter, the figure the other party offered to his clients was almost 2%, which he considered too low. Uwa said since the case was an oil-related matter, there were specific laws guiding the sector and called for independent valuers to do an evaluation. He said in order to explore the opportunity given by the court, the day's proceedings should be put off. The judge thereafter gave the parties the last chance to explore out-of-court settlement and fixed March 23rd for a report of settlement. Meanwhile, the two aggrieved directors have asked Adegbulugbe to give the shares he was alleged to have illegally acquired to the original owners. Alaibe and Olojede made the call in a defendant's counterclaim in support of the amended statement of defense filed before Olajuwon. In the application, they joined Adegbulugbe, Ms. Orowole Ibineza, Mr. Olusegun Ilori, Global Bright Investment Limited, Grand Energy Limited, and Mr. Kayode Adegbulugbe as second to seventh defendants to counterclaim and asked the court to summon them as third party. Alaibe and Olojede prayed the court to declare that all the shares allotted to and currently held by Adegbulugbe, Mr. Segun Ilori, Glory Bright Investment Limited, Grand Energy Limited were illegally allotted and acquired, and the said allotments were unlawful, null and void. That an order for account to be rendered by Professor Adegbulugbe and Kayode Adegbulugbe of all the income and expenditure of the plaintiff, and for them to pay to the existing shareholders of the plaintiff as dividend such amount as is found to be the profit from the business since inception in the proportion of their shareholding. An order of perpetual injunction restraining the defendants to the counterclaim from continuing to run their affairs and from interfering in the operations, management, and control of the company. And an order directing the following remaining valid shareholders to call a general meeting within 7 days after judgment in the suit delivered for the purpose of determining how business would be conducted going forward.